evening, ladies and gentlemen. Thank you for your patience in waiting for the start of the talk. As you'll know, that there has been some problems on the London Underground, so we have delayed the start of the evening just by a bit in order to give other people a chance to catch up, and I'm sure there will be people dribbling through as we go through it. The plan, therefore, is to take the same amount of time as we had originally scheduled, but we'll just be eating into the wine and the snacks a little bit. So hopefully your tolerance there would be appreciated as well. So, my pleasure to introduce our speaker tonight. I'm Sue Wade. I'm the chair of the Howard League, and I have the pleasure of introducing Lord Carlile tonight. Lord Carlile led our inquiry 10 years ago, and I had a great pleasure in working with him on that. You'll know his background, so I'm not going to go through it in great detail, other than to say that in addition to the work that he did for us 10 years ago, looking at violence in institutions, which we'll hear a little bit about in terms of reflections today, you'll know he's also done a number of other inquiries and is also an expert on security and terrorism as well. For me, one of the interesting and the critical things that we wanted Lord Carlile to bring to bear was both a combination of his amazing and deep legal knowledge, but also his humanity and his ability to pay attention to the lives of individuals within those inquiries. And that, for me, has been a real strength of the inquiry, and I'm looking forward to his comments on those things tonight as well. So, Lord Carlile, thank you.
Well, thank you very much, Sue. It says here, in a note that I wrote for myself, that I was going to thank you for the privilege of being asked to give this lecture, and I do thank you for the privilege of being asked to give this lecture. However, the real truth about why I'm giving this lecture is that Francis Crook told me to. And I've learned over many years of being a friend and admirer of Francis that it's always much better to say yes than to say no, particularly if, like me, you like a zero inbox at the end of the day. I think it's a respectable tradition on these occasions when one is giving a lecture named after someone to say something about the person after whom the lecture is named. And it's a particular pleasure to say a few words about Milo Cripps, Lord Parmoor, for what an interesting person he was. Of course, his greatest virtue is that he left, really at the time, what we thought was quite an extraordinary amount of money to the Howard League. And that money has made a huge difference, hasn't it, to the functioning of the Howard League over the years since, and will continue to do so. He was most certainly not the typical donor to something like the Howard League for Penal Reform. He was an aristocrat, a genuine aristocrat. He was a businessman. He was called Milo, which was not particularly common in those days unless you were an aristocrat. He was born in 1929. He went to Ampleforth School, Ampleforth College, where his aesthetic interests were encouraged. And indeed, when he died, he left Ampleforth Abbey 4,000 volumes of his non-antiquarian library as a bequest. He got a scholarship to Corpus Christi College, Oxford, when he was 16, which even in his day was some achievement. But he didn't take it up immediately. He went off to do national service first, where other soldiers knew him as the scholar, because he used to write their letters for them. He finally went up to Oxford, but he never took a degree, because, as his biography puts it, his years there were characterized more by high living than serious study. He drank too much and left Oxford with no clear idea of his future. He then had a magnificent business career with the banker Zygmunt Warburg. After starting in Warburg's in the modest position of a filing clerk, he created a great capital company, and he bought an antiquarian book business at Quaritch in central London. He developed that business through his aesthetic interest. One of the most extraordinary things he did, as long ago as 1983, he arranged the sale at Sotheby's of a 12th century Romanesque German manuscript, the Gospels of Henry the Lion, Henry being Henry the Duke of Saxony, and he was the first person to administer the sale of a book for more than £8 million in 1983. I mean, what a guy he was. And eventually, in his retirement, he didn't let up on his interests, and he broadened them, and he became a national authority on the great crested newt and its place in the garden pond. Now, what a wonderful thing to focus on when you become a little less mobile in your old age, if you have a garden pond. He sold Bernard Quaritch, the booksellers, in 2004. He decided that he was going to have arrangements made when he died for a party for his friends. But he thought, if I have a party after my death, I won't be there. So instead, he held 2 farewell lunches for his friends before he died. After drinking too much as a youngster, he became a teetotaler for the last 45 years of his life, but he took to an interest in food. The celebrated cook, Jennifer Patterson, in her will, left him a potato ring. So if nothing else remains in your memory about this lecture, I've told you some things about Lord Parmoor, which I really absolutely love. And, you know, there's a point in this. Isn't it marvellous that there are still a few Renaissance men and women who are actually prepared to indulge their interests, but at the end of their lives leave a bequest that goes to something like the Howard League and does so much for people who are completely unlike he was, because he was very advantaged in life. And thank heavens for Lord Parmoor, and that's why we're here today. These are exciting times. Rumours have it that lurking in some booth in a restaurant, you might shortly find those 2 very close friends, Francis Crook and Michael Gove. Now, if you had said to me 25 years ago that Francis Crook would be inviting to the Howard League, as you did, a Conservative Lord Chancellor, and that genuinely we felt that there was reason for talking to that Conservative Lord Chancellor, at that time I would have been surprised. But there's an awful lot going on at the moment, mostly thanks to Michael Gove and those who campaign to Michael Gove. And we must take full advantage of it, because there may be a cabinet reshuffle at some time in the not-too-distant future. When this cabinet was formed, of course, all we said about Michael Gove at the beginning was, thank God he's not Chris Grayling. But actually, it's been amazing these last months, and I'm involved in a number of activities which are not Howard League activities in relation to, for example, the reform of the youth courts, and there it is, open season. So we are in an exciting time to be talking about the sorts of issues I'm going to discuss seriously tonight. In 2005, published in January 2006, we had our review into the use of restraint, solitary confinement and strip searching in penal institutions. And that inquiry started because of 2 very sad events, the deaths of 2 15-year-olds, Gareth Myatt and Adam Rickwood, by their own hands. The rationale of the inquiry was the rule of law and the protection of human rights for children. And it was based on the proposition that the protection of human rights of children and the rule of law should apply to all children equally, regardless of whether they were in the community and had not been in any trouble, or whether they had been in trouble and were detained. And a principle behind it was that their treatment in custody should not risk making them more dangerous, more likely to commit crimes or antisocial acts, or more violent on their release than on reception. And another aim was that they should not come out of custody with the inevitability of going round the revolving door again within weeks or months and going back into custody, and that they should not be marked for life as criminals. And the results were not looking good when we started the inquiry. I think what I learned during the course of the inquiry, because I hadn't looked in great detail at the subject before, was that the cohort we were looking at, some of them were very small and puny, and some of them were very large and intimidating. But whether they were large or small, they were all children. And there was a danger that the sort of young thugs description, beloved of certain newspapers, including one that occasionally pays me to write articles on Sundays, so I won't slander them for that reason, were all too ready to slur and castigate the whole cohort of children who got into trouble. Our recommendations, I will summarise, the important ones. First, that restraint should never be used as a punishment, and that restraint should never be used to secure compliance. Second, that the infliction of pain might be unlawful and in any event was always unacceptable. Thirdly, that strip searching, which was a ubiquitous practice, every single young person taken into custody was strip searched on arrival, should be risk-led. In other words, it should stop, except for cases where there was a clear risk. And fourthly, that prison segregation units should not be used for children. When I paid my first couple of visits to young offenders institutions 10 years ago as part of that inquiry, I was absolutely appalled. I was shocked beyond belief. By then I'd been involved in the criminal law for more than 30 years. I'd been an advocate, I'd sat as a judge. I had no idea that children were being sent off to custodial institutions and sometimes were being segregated not only for long periods, but in the most disgusting and revolting conditions you could ever imagine. It was like stepping back into the early 19th century. And although there have always been some very good people in the prison service, there was a sort of culture that it was okay and that it was part of the process, and that was it. I was appalled. At that time, nearly 3,000 children were in custody, and there have been significant changes since then, and I'm going to deal with a few gains that have taken place over the last 10 years now. The first gain is that there were 3,000 children in custody then, and the September 2015 figures show the custody population, including 18-year-olds, at 1,049, and under 18s at 981. So it's been reduced by 2/3. And I give credit where it's due to the Youth Justice Board in particular, on this issue at least. I think Francis Doane gave good leadership to the Youth Justice Board, and hopefully we will continue to see a reducing population of under 18s. The number of split-site institutions has been reduced from 9 to 2 over that period. Significantly, the number of girls in custody, in 2005 it was 241, and in September 2015 it was 32. So that is a significant gain which we should welcome. And, you know, with only 32 girls in custody, we are probably near to the irreducible minimum, given that there are always going to be one or two cases, a few cases, where custody might be inevitable. We have a situation in which unannounced inspections are carried out in all establishments at least once a year, which is something we recommended in our review. Social workers are now centrally funded so that they work in all penal institutions, are not subject to the vagaries of regional chance, and there have been advances in the provision of education, mental health assessments, treatment, and staff training too. Just a word about education. When I went into a few of these establishments, I began to recognise the good and the bad education units, and eventually, I mean, this is absolutely true, I could do it by smell. I could smell a good education unit because it didn't smell musty. And, you know, obviously there was a lot more on the walls as well, and you could smell a useless education unit by the fact that it went musty. And education is extremely important. And forgive me if you've heard me tell this anecdote before, because I've told it often, but I went to one institution and a young lad of about 16 or 17 asked me if I would go into his cell, his room. And I went in, and there were maths certificates all over the wall, including a grade A maths GCSE. And I asked him a really stupid question: do you like maths? Because it was actually obvious. And he said, I love it, sir. I want to be a maths teacher. And I said to him, were you good at maths at school before you came in here? And he said, I never went to school, sir. Now, in the course of about a year and a half, that boy, who had a natural flair for maths and was obviously very intelligent, had found, and I hope he is a maths teacher now, had found something that was going to be at the centre of the whole of his life. And that was because there was a good education system in that institution. And if we've helped a little bit to encourage that, then I'm proud of sharing in that achievement. And also on the plus side, the number of child arrests has reduced almost by 2/3 since 2008. And even if arrested, at least some kids who are arrested are being sent off by the police to diversion schemes. That is good, but there is evidence of regional inconsistencies in the use by police of diversion, and there may be evidence, when I've spoken to other people about it, they say there is, that it's the easy kids who are sent off to diversion schemes, the ones who have parents who are angry with them and who actually have a decent family life, a reasonably cohesive home, whereas looked after children are much less likely to be diverted and so end up with a criminal record, whereas the diverted children don't. The number of white boys in custody has reduced at double the rate compared to the number of black, Asian and minority ethnic boys. So there's a plus and a minus here. In September 2006, there were over 2,100 white boys in custody, 75% of the cohort, and 736 black and minority ethnic, 25% of the cohort. The numbers have gone down dramatically. The number of white boys in custody has decreased from over 2,000 to less than 600, now 60%, and the number of black boys in custody has gone down from 736 to 395, 40%. So, of course, one conclusion is there's a disproportionate number of young black males in custody now, and that is plainly something that needs to be addressed. My own view, and it's easy to say this because I know Francis Crook agrees, is that nobody should be sent for very short sentences anymore. I heard the words at a serious meeting yesterday uttered, short, sharp shock, and a frisson went through me. and we may have to persuade the Lord Chancellor that the words short, sharp shock are like some awful form of slaughter of animals and should be forgotten about. Now, I want to turn to some specific issues. First of all, I want to talk about safeguarding. Her Majesty's Chief Inspector of Prisons has said, in all establishments housing children, there are fights and assaults almost every day. That tells me that there is insufficient control over violence and bullying. That should have changed over the last 10 years. Furthermore, since the inquiry, there have been 5 more deaths in prison within the cohort. 2007 at Lancaster Farms, 2011 at Wetherby Prison, 2012 at Hindley, January 2012 at Cookham Wood, and 1 in July 2015. And at least in relation to all those events, apart from the last one, for which no inquest, as I understand it, has yet taken place, there were systemic failings, failure to protect, cries for help, prevention that wasn't taken up, and in one case, as it was put, numerous failures. In September of this year, prison inspectors were in a young offenders establishment when they actually witnessed a shouted kangaroo court in which some residents were effectively trying by shouts through locked doors another who was being very seriously bullied. So there is a great deal of work to do. The Harris Review, Changing Prisons, Saving Lives, in July 2015, as you will know, was asked to review the self-inflicted deaths of young people aged 18 to 24 and children between 2007 and 2013. It made as many as 83 recommendations. Well, if a report makes 83 recommendations, it suggests that it's all not going very well. And it said, unless progress is made on the proposals that we've made, young people will continue to die unnecessarily in our prisons, and we will continue to waste countless millions of pounds in failing to rehabilitate those who can be rehabilitated, in locking up those for whom a non-prison option would be more appropriate, and in failing to intervene early enough to prevent people from entering the criminal justice system in the first place. That's a very serious indictment of the system. If one applied the standards of civil litigation, huge sums of damages would be awarded for negligence with foreseeable consequences. And where the foreseeable consequence of neglect is that troubled children will take their own lives, then, in my view, urgent action is needed. I'm now going to turn to restraint. And my headline for this is, creakingly, something has been done about restraint, but it's not enough, and that progress has been horribly slow. I think that ministers have, in all governments, because we've had different forms of government, we've had 3 different forms of government since then, have failed to grasp the issue, and it's one of those unpalatable issues that is easily put in the pending tray. We recommended that it was a matter of urgency to develop and implement one safe and certified technique of restraint to be used on children. In 2012, that's 6 years and some months after we reported, the then government announced a new system of restraint for use in children, MMPR, minimising and managing physical restraint. So, having announced that in 2012, one would have expected energetic implementation. Well, on the 18th of November of this year, the Inspectorate of Prisons offered a review of the early implementation of MMPR, and I quote, "The combination of delay, resource pressures, a more complex population, and concerns about overall performance means that the new MMPR system is not yet being consistently implemented or achieving the intended outcomes." Now, that's a pretty shocking statement because we're not talking about building Typhoon fighters that cost N million pounds each. We're talking about training people in physical techniques, and the training is cheap. I've been on some of the training, by the way, and there are experts who can deliver it. It's just a question of will. They added, this is the Inspectorate, "We welcome the significant improvements that it has brought to the national oversight of restraint and the greater focus on communication and de-escalation as part of a wider approach to behaviour management." Insofar as I understand that statement, I welcome it, but I think what it conceals is that there's been a struggle to implement these improvements. They also said, "MMPR does not allow staff to take children to the floor intentionally during a restraint because of the medical risks this proposes to the child. But in nearly half of the incidents reviewed, including 70% of those in YOIs, children ended up on the floor." So in 70% of the cases, it's not working anyway. So there is a crying need to move things forward. And indeed, in the annual report of the Prisons Inspectorate for 2014-15, they said the use of restraint has increased at 3 institutions and decreased at 2. "We continue to find evidence of the use of pain compliance, an approved technique that we regard as unnecessary and unacceptable for this age group." Now, those comments are, of course, predicated on restraint being permissible and necessary. My preference would be to see no physical restraint used on children in custody. We had an engagement in 2005 with some local authority secure children's homes, LASHES, and in the ones I visited at least, there was very little physical restraint used, because the employment practices in those establishments meant that staff took the time to sit down and de-escalate. In one instance, they told me that it had taken them 7 hours to de-escalate, which of course may be very tedious for those involved, and they'd done it. And on the face of it, it looks a very expensive use of labour. However, when you do a real cost-benefit analysis of that, if it takes 7 hours to de-escalate a particularly difficult child, but that is done by talking to the child, maybe the benefit of that is far greater than the cost, because that child will have seen that when they kick off, they're not met with violence, that people can be reasonable. And let's not forget, and this is an observation I've made over many years now, that for many children who find themselves in custody, the cell in which they spend a lot of their time may be the most comfortable room in which they have ever been for any length of time. And they may be actually receiving more affection from their friends and some of the staff, I mean in a perfectly proper way, than they have ever received in their daily lives. So when we're looking at restraint, maybe we should be paying more attention to the cohort. I turn now to segregation. Unfortunately, very little has changed since the inquiry. Over 25% of boys held in custody have been in 25% of boys have been in segregation at some point. In one case, at Cookham Wood, one boy spent 133 days in segregation. 133 days. It is actually unbelievable until you see it and learn about it. In total, in 2013-14, children spent 7,970 days in prison segregation units. And bearing in mind that a lot of those segregations will actually be quite short, it shows how many must have had repeated segregations during their time in custody. The Prison Inspectorate's annual report for 2015 says that conditions remain poor, and I gave you my view of the conditions that I saw. The National Preventive Mechanism's 6th Annual Report, 2014-15, said that while efforts have been made to strengthen the procedures and safeguards for formal isolation across many forms of detention, there were too many instances in which governance was poor and further efforts to avoid isolation were warranted. It was of particular concern that the governance of isolation for children was still not robust enough, and that oversight processes did not shed light on the reasons for or address any disproportionate representation of detainees from certain protected characteristics in isolation. Now, translating that into English, what it means is too many kids with mental health issues were being put into isolation. And, you know, it doesn't need, I mean, there will be some expert psychologists here, I guess, but it doesn't need a psychologist to tell you what the consequences of that can be. Also, worryingly, the National Preventive Mechanism members found informal isolation and solitary confinement that arose from restrictive regimes or temporary measures and the decreasing staffing levels in many places of detention contributed directly to the use of informal isolation. Well, there just shouldn't be any informal isolation. None. Zero. Zilch. It should be over. And, you know, my view is that we should not be seeing the total days of children in prison segregation in thousands of days. We should be seeing it in tens of days overall. I turn next to strip searching. When I first went to young offenders institutions as part of the 2005 inquiry, it was a given that, you know, they showed me proudly the sort of dressing gown arrangements that meant that a child going into custody would be strip searched in their top half first, which was rolled down, male or female, and then the top half was put back on and the bottom half of the gown was raised for the searching of the bottom half of the body. And somehow or other, it was thought that this made strip searching okay, whatever the circumstances. Now, you know, that in my view is and was shocking. The idea that there should be universal strip searching of young people, most of whom were completely disorientated by what was happening to them, often arriving tired and hot at an institution in a bus that stopped at other places, having taken 2 or 3 hours coming from court. It was the sort of conduct which made children totally dissociated from what was happening to them. But it is fair to say that there were a lot of people working in those institutions who felt uncomfortable about it too. Routine strip searching in secure children's homes and secure training centres, including strip searching on reception, was banned. And I do welcome that. And routine strip searching has been replaced by a genuinely risk-based approach. And there seems to be evidence that the risk-based approach is working. Routine strip searching of 17-year-old girls in prison services unit has been replaced by a risk-based approach. Partly, or perhaps mainly, I better say mainly, because of Howard League lobbying, prison rules were changed so that children do not have to strip on arrival, and that situation has improved greatly. Nevertheless, we must be vigilant. strip searching was actually a form of institutionalised bullying of children. There remains much work to be done, despite the measured successes that there have been since 2006. Obviously, there is still the work on the use of restraint. In my view, post-sentence care is still inadequate, although more interest generally is taken in what happens to a child on release, and there is a greater focus on some form of continuity of care from custody through to whatever happens after custody. Nevertheless, too many children are being sent to places where they have never been before, where they basically don't know anyone, and where the temptation to fall into crime is all too easy. And in my view, we do need to have more post-sentence care. And above all, preparation for post-sentence care. I was involved fairly recently in a parliamentarians' inquiry, and I emphasise it was not a parliamentary inquiry, but it was by parliamentarians into the youth courts. It was funded on this occasion by the CEIF Foundation and the National Children's Bureau. We identified a number of issues, and I'll just mention three. One is the competence of advocates and the judiciary. As a barrister and parliamentarian, I've reached a stage in my life where I don't care if occasionally I offend the judiciary, so I'm prepared to say it. I retired from all my part-time judicial roles at the end of last year in order to collect the pension. The evidence that we collected in our inquiry was that there is very little training in youth court issues of the judiciary. There is some, but not enough. And there is almost no training of advocates. One could say that there is no training of advocates. We recommended that no judge should sit in a youth court unless they're ticketed to sit in a youth court, including lay magistrates. Judges are very willing to be trained, actually. They enjoy the training enormously for the most part. It gets them a day out of court, and they learn some interesting things. And we believe that advocates who appear in youth courts should be ticketed. They should have to go through training in order that they can appear there, because it is a special form of work. It's a specialist form of work. My first contested case as a barrister, aged 23, was in the Camberwell Green Juvenile Court, as it was called. I'm happy to say that my client was acquitted of causing criminal damage to the caretaker's window. The fact there was a caretaker shows you how long ago it was. I have no idea to this day how he came to be acquitted, because I had no idea what I was doing. I knew I was supposed to ask the caretaker a lot of questions, and I suspect I asked him far too many, and in the end the magistrates gave up and thought, we better let this guy off because his barrister will go on longer. And it is still the case, and the solicitors and barristers here will recognise this, that often it is the most junior person who is sent off to the youth court. In barristers' chambers, it's often a brief that's thrown by a friendly, literally, thrown at the barrister by a friendly junior clerk at 6 o'clock in the evening saying, you're in the Camberwell Green Youth Court tomorrow, miss. Here's the brief, chuck. And, you know, for very young barristers, they don't even know if they're supposed to wear a wig and gown in the youth court the first time they appear there. That cannot continue. To be fair to the Bar Standards Board, they've produced a very good report on this issue and are prepared to take on this ticketing proposition. I would urge any solicitors here to wake the Law Society up to the fact that this is an issue which can be dealt with very briefly. There are plenty of reports on it, and actually solicitors' livelihoods are not going to be destroyed if some members of their staff have to go on a short training course in the youth courts. And the final issue, I said I was going to raise three, but we're going to raise two. And this is really important because it is literally happening now. And this is about the problem-solving approach in youth courts. The Lord Chancellor is really interested in this. He's been asking for evidence from all over the place. I am going to a dinner on Monday night next week with him, at which he's brought together a group of people who are interested to talk about how problem-solving can be introduced, and not just in the youth courts, how there can be continuity from the disposal of the case onwards, so that the judge or judges actually review what has happened and have some flexibility. And he's genuinely interested in how this can be done. There's always a danger that a minister will seize onto something that's been done in another country. He's very interested in some work that's been done in New Jersey, in Newark, and somebody will be there at this dinner from Newark. But the opportunity to move to a problem-solving system for lower grade cases at least is extremely welcome, and we should embrace it. So I think my summary is that our report produced some useful material. It's taken longer to implement our recommendations than I ever would have wished, but here we are, we're still talking about it, and we believe that there is still room for reform that we, with the Howard League, can achieve. And I welcome the opportunity to come and talk about something I did 10 years ago. Mostly I've forgotten what I did 10 years ago by now. I'm very grateful for the opportunity to remind myself of this. Thank you all very much for coming.
Thank you, Lord Carlile. That was a really good summary of some exciting times, because we went to some tough places.
We did.
And saw some really tough situations. And I always remember your sort of briefing afterwards, and being able to say something quite pithy about some of the things that we'd seen, including the standards in the kitchens and things, if I remember rightly. So, 10 years on, Lord Carlile's given his view about what things have improved and what things still need to do, but we have the opportunity now for some questions from the floor, and that Lord Carlile's quite happy to sort of develop that in a bit more detail. So, questions from the floor. I think there's a microphone coming down to you.
Thank you. Good evening. Thank you very much. Just a quick question. For the youth offenders that are in institutions, and if they're in a hospital wing or if they're a mental health patient, do the rules of seclusion and the new code of practice apply to them?
You're talking about mental health?
Yeah.
Well, I think the situation has certainly improved. The mental health provision in institutions that hold young offenders are much better than they used to be. I think the main reason for that is because the NHS care is now provided by the National Health Service, and health trusts generally try to provide a reasonable level of care. But you're shaking your head, and you're absolutely right to shake your head, because standards vary around the country. I mean, there are people here who are much more up to date and much more expert than I am on the current situation. I'm looking around the room because I can't see Laura James. Where are you, Laura? Where's she gone? Oh, you're there. Do you want to say something about, in a loud voice, Laura, about that?
In terms of the procedure for people who are detained in mental health hospitals, then the standard rules for all patients apply. And there's a new code, I think, introduced in April of this year, which introduced an awful lot more safeguards and protections. Section 26.156. There you go. So, but the situation for children with mental health problems in prison is dire. They don't have anything like that.
There's no provision for the Mental Health Act or not?
No, absolutely not. No, they fall under the standard provisions for any person that is segregated in a prison So they will have the procedures that apply to good order and discipline if they're there for their own safety, which we know are woefully inadequate. There is, following a Supreme Court case that we intervened in earlier this year, finally now a provision for external review by the Secretary of State, not by a clinician, not by a doctor, by the Secretary of State. That's exercised by the Deputy Director for Custody, and it will be, in the case of children, after 21 days. That's 7 days after the rapporteur and torture says irreversible damage can set in.
Thank you. Well, that's a pretty... Thank you, Laura, very much, because you're much more up to date than I. That's a depressing situation. I mean, in principle, my view is that there should be... If a child has a significant mental health condition, they shouldn't be in a custodial institution. They should be in a CAMS unit, if at all possible.
Yes, right, just over third row back here. Thank you.
Thanks very much. My name is Anne Fox. I'm the new Chief Exec of Clinks. It's a slightly related question to that, not really related to the new day job. But I was previously the Chair of the Council for Disabled Children. And my comment is following on from that is the increased use of assessment and treatment units for children whose behaviour challenges others as a diversion where children basically are kept for indeterminate lengths of time. And there's just been a very tragic but interesting inquiry into the death of a young man who was detained for 107 days before he died of an epileptic fit in a bath, and the inquiry has just come back and said that he never should have been left. He shouldn't have been bath unsupervised, and this was there on day one of his assessment. But I think there's some interesting learning from your review that could go to colleagues in mental health around this increasing use. There are children hundreds of miles from their families, where often, you know, there isn't care in their community, so they go for indeterminate amounts of time because the needs that are assessed cannot then be met, and they have to be met, so they're kept in the unit. Yeah.
I don't think I can add anything to your eloquence on this subject, actually. What I would say is that I've taken a long interest in mental health issues right across the board for many, many years. And we have seen a great improvement generally. Although mental illness is still stigmatised, the word parity in that context did not exist 20 years ago. Now it exists and it's taken seriously. The coalition government, through the good offices of Norman Lamb, who I'm delighted to say is a member of the same party as me, actually took the issue very seriously and put more money into mental health. But just a little story. I used to be on the governing board of a children's hospice in the West Midlands. And like Great Ormond Street, it was very easy to collect large amounts of money and do things like improve the duvets in the hospice. But we eventually decided that we had to do something a little bit more challenging. So we set about raising money for a children's mental health hospice, which was to be based, and I think is based, in Colwyn Bay. It was a formidable challenge to raise money for that, because people do not see mental illness, even in children, in the same light as they see physical illness, which has a sort of cuddly element to it, if you like, you know, teddy bears used as powerful emblems. And I'm all in favour of raising lots of money for physically ill children, but I think there should be parity in the fundraising for mentally ill children, which would provide more diversions into mental health settings and less custody for children who had florid mental conditions.
Okay, there's a questioner at the back.
Yeah, good evening. My name's John Graham. I'm a therapeutic counsellor and I specialise in addiction treatment with people caught up in the criminal justice system. In particular, I work for RAPT in Wandsworth Prison and various other prisons. And I haven't actually got a question, and I must say I'm feeling very emotional. If you put an S into your name, that would be eponymously my hometown. And since, you know, Carlile was where I was born and brought up, I just want to try, if it's at all possible, sir, I just want to communicate my appreciation of your humanity. Because the truth is, the fact is, that I've gone full circle. I was put in a Victorian standard remand home at the age of 12. I was in a proof school at the age of 13. I was in Borstal at the age of 16. And I've served 6 prison sentences in this country, a prison sentence in Germany, and a period of time in the central prison in Peshawar in the northwest frontier province of Pakistan, where you had to find the wood to build a fire to boil the water with if you wanted a cup of tea. But what I want to communicate is that I went through everything that you've described tonight, the extended isolation, the bullying, the very, very severe, short, sharp, shock type treatment, and the way you came across and the effort you've made to reform all of that, it's not only commendable, but your humanity shines through. Thank you.
Well, that's made my week, especially as my wife is listening. So thank you, sir. And, you know, actually, I think people like, if I can return the compliment, people like yourself who've experienced the system are often the best advocates for change. And the work you are doing as a counsellor is absolutely beyond value. You know, I've always said, I've done lots of inquiries, and I've always said in any inquiry, among the evidence you find, my working word for people like you is angels. And the trick is to bottle what the angels do. And it's often very difficult because it often turns on personal skills, which are quite difficult to replicate. So thank you very much. I do appreciate that.
Okay, last question, I think, because the... yes, that's, yours is, yes, absolutely.
We've time for 2, haven't we? Because
Two,
that
okay.
lady wants to ask
Fine.
a question.
I ask as someone who knows absolutely nothing about either side of this sector, simply to be informed. The kid with the maths GCSE, what were his real chances of becoming a teacher? I always understood that, just from my vast experience of sociology A-level, that your crime was written off after a certain time, but that seems to have got a bit wobbly.
You've absolutely put your finger on an issue. One of the things that my parliamentarians' inquiry identified was that convictions whilst a youth, whilst a child, do follow for a period of years, and it is quite difficult for particularly teachers to overcome that stigma. One of the things we therefore recommended was that the slate should be wiped clean in terms of having to reveal convictions when someone reached 18, unless either there was some special feature about the crime that had been committed that justifies an exception, or it was so recently before the 18th birthday that there should be an extension of the time before the slate is wiped clean. But as a principle, when somebody reaches the age of 18, the slate should be wiped clean, and the kid who got the A-grade GCSE is actually a good example. I'm confident that his maths would have been progressed because it was so obvious that he wanted to do nothing else. But that may be a bit of a one-off case.
Hello, Mary O'Shaughnessy. You've very rightly identified that many of those young people who don't receive out-of-court disposals are those in the most disadvantaged. And also, I'd urge you to encourage the Lord Chancellor to allow those young people to get opportunities to traineeships and to employment in the community, because I've found is a lot of the time when they're exposed to adults who can support them, support and guidance, they do react very, very well. It doesn't come as a cost. And in fact, even if they don't turn their lives around completely, they do have a chance that somebody sees them for what they are and is there who cares for them, not because they've been paid to care for them, but as in many of my colleagues who say, that could be my son.
Well, I absolutely agree. I mean, there are children for whom the reflex, until somebody tells them that it's actually not acceptable, is to punch someone who's annoyed you. but actually that gets you into jail. And it is often a diversion, well run, that can persuade a child to say, oh, really? You know, I'm not supposed to punch someone who's annoyed me. And, you know, the police are sometimes very good at this as well. You know, the police can be very competent. I'm the chairman of something called the London Policing Ethics Panel. I and my 4 fellow panellists have been out on night patrol with the police in parts of London. And just to close, I'll give you this story. I was out one night from Stoke Newington Police Station with 2 officers who were called to a fight outside a nightclub somewhere, one of the many nightclubs somewhere near Old Street, Shoreditch sort of area. And there were 2 men who'd been having a pretty serious fight. And the police arrived. The first thing they did was separate them. And I thought, right, well, the next thing, there's a police van here already. They're going to be shoved in the back of the police van, charged with a fray or something, and they'll have a criminal record. And they looked like 2 moderately respectable guys. Actually, what the police did, 2 pairs of police officers stood them apart, about 2 yards apart. They allowed the girlfriend of one of them to stand right by them and stroke her boyfriend's face to calm him down, which worked. And at the end of the episode, experienced police officers said, right, you 2, you've got a choice. Either you can come to the police station, there's a van, or you can shake hands, apologise to one another, and you go that way, and you go that way with your girlfriend. And guess what? They shook hands and went in opposite directions. Now, that is a form of diversion. It wasn't what I expected, and I thought it was magnificent, actually, because it's applying common sense and not just the rule book.
Well, thank you, Lord Carlile, and thank you for being here, despite the difficulties in terms of the transport and waiting for us to start as well. I think just to finish up, a reminder to you that the Howard League is continuing to look at this particular issue amongst many others. At the moment, what we're paying attention to a lot, you've heard about the successes on the child arrests, but we don't sort of rest on those sort of things. So we're looking at some of the issues to do with where children are held in custody. Our view 10 years ago, and still is, that the large institutions that the state provides are not the place, and we've really criticised government for removing the contracts for local authority children's homes, and we're looking at those sort of things again. We're really unhappy still about restraint, as you can imagine that we are, and we're really unhappy about the both the regional differences, but also the completely unacceptable disproportionality in terms of who's sentenced to custody now. It becomes more and more obvious as the numbers come down. There are really good successes, and we're really pleased with those, but we don't sit on those, so we can campaign. We're also just about to start our 150th anniversary year, which means a lot to us. Oldest penal reform charity in the world, oldest charity with NGO consultative status in the UN, and we're doing a lot of celebrations for that, so please look at our website, and if you haven't joined us, please do so. So thank you all for your patience, and look forward to seeing you in the refreshments afterwards. Thank you.